Good evening, you're watching Left, Right and Centre. I'm Vishnu Shom. In a victory for personal liberty and the freedom of expression, the Supreme Court has ordered the release of Mohammed Zubair, the Alt News fact-checker, who was slapped case after case for apparently hurting the sentiments of some. Today, the Supreme Court called out the vicious cycle of arrests and said, and I quote, "It's a set principle of law that power of arrests must be pursued sparingly. In the present case, there is no justification to keep him in continued detention and subject him to an endless round of proceedings in various courts." The special investigating team of the Uttar Pradesh police has been disbanded. The case now will be investigated, the various cases, by the Delhi police. And he has the right to move a court to try and quash the FIRs or the cases against him. At the moment, Mohammed Zubair will soon be out on bail, a free man. On the show tonight, will the harassment of Mohammed Zubair, a fact-checker and journalist, now finally end? Also on the show, the veteran Congress leader Margaret Alva joins me in her first interview since she was nominated as the opposition candidate for the post of Vice President. The numbers appear against her. She says her battle is one to forge opposition unity at a time when democratic institutions in India are threatened and the freedom of speech, even in Parliament, lies in tatters. But first, my panel on what the Supreme Court has ordered in the case of Mohammed Zubair, who's going to be out soon on bail. His freedom, his liberty has been assured, at least for the moment. Aman Lekhi, the senior advocate of the Supreme Court. Ashutosh, the columnist and author, joins me. Swati Malik of the Congress. Ranbir Singh Pathania of the BJP. Aman Lekhi, the key point, one of many important statements made by the court, the power of arrests must be pursued sparingly. Isn't this key in a case where FIR after FIR has been slapped on this man?
Yes, Vishnu, I want to make 3 points. One, the Supreme Court is correct that as far as the power and necessity of arrest are concerned, they are two distinct things, and the existence of power doesn't necessarily mean that there should be an arrest. But I'll add 3 more aspects to it. One, I feel 153A and 295A are added almost mechanically when the two are actually distinct, and so it leads to multiplication of the sections with which a person is charged. So there has to be some mindfulness of the section invoked. 2, and so far as 295A is concerned, because in a religiously surcharged environment like ours, I feel that there has to be a change, because as far as investigation is concerned, FIR, but it's a Nupur Sharma or for that matter, a Zubair. For the purpose of investigation, there should be sanction. And 3, and that's very pertinent, I personally feel the use of religious motives and political discourse should be avoided. This is a line which is consistently breached. In much the same manner as other instances are concerned, insofar as Zubair's comment is concerned, yes, we stand up for free speech. You had mentioned allegedly hurting religious sentiments. I don't think there's anything alleged about it. The use of the expression out of a 25-year-old movie in the circumstances in which was there was inappropriate. But that said, the manner of dealing with this particular case is also wrong. And in these particular aspects, what is very significant is that in far as 295A is concerned, it deals with a class of citizens. So whether it is Nupur or whether it's Zubair, because it's dealing with the class of citizens, you only need one FIR.
No, but Mr. Lekhi, just to interrupt you, did you just say that there was something offensive in the initial tweet on that 25-year-old movie which he'd put out? Because a lot of people would suggest that it was just a tweet. If we draw offense from anything and everything which is tweeted, then we may as well shut down Twitter, shut down programs, shut down everything. Let's stop talking. No, was it really genuinely something that deeply offensive? Let's use our common sense in this as well.
No, insofar as a time-worn tradition is concerned, offense and injury are two different things. I'm not talking only of offense. The question of a criminality is in addition to offense, injury. I'm talking about the broader perspective. What I'm saying is that when you make a political comment, there's a tendency these days to bring in religious symbols into political comments. Now, when you make a political comment, it's inappropriate in that event to mingle two absolutely distinct concepts, because in that event, in the garb of free speech, there can be easy contempt to religious sensibilities, which should be avoided. And as far as this aspect is concerned, it's not so much simply the tweet as such. What I'm pointing out is the method in which comments are made, and equally wrong is the way in which the comments are dealt with. So I personally feel both in the tweet as also the method of dealing with the tweet, there's an error. And as a consequence of which, as a consequence of which, the larger issue, that is insofar as the bringing in of some kind of cyclical features in the surcharge environment can easily be avoided.
Okay. You say that in a surcharged environment it can be avoided. A lot of people would suggest that this, there may be a surcharged environment, but that shouldn't stop somebody from expressing a certain viewpoint, particularly when
I'm not for a moment saying that you should stop expression, and that's what I'm saying. What I'm saying is there are two wrongs over here. As far as the way of dealing is concerned, I personally feel for the purposes of 2018 tweet, an FIR was unwarranted and arrest completely unnecessary. Insofar as the other FIRs are concerned, the FIRs, in my opinion, were also unnecessary because subsequent FIRs more or less the same issues, particularly the hate mongering issue is, in my opinion, completely unnecessary too. But that said, when you're dealing with the method, as the method is wrong, I don't in any way deny the fact that the way of dealing is inappropriate. What I'm saying is that the comment to the subject matter of the method should also have some element of restraint in dealing with it.
Okay, got it. Got it. I get that point. Ashutosh, do you agree that the comment and the method used also need restraint? A lot of people would suggest there was nothing wrong in the method and there was nothing wrong in the comment, because that's the bottom line over here.
See, a state will always have a problem with the free speech, and that's why the state is the first agency which always wants to curb freedom of speech, and which is the fundamental of a democracy. So state, any kind of state, and especially the most centralized state, always have a problem with the free speech and always like to have a problem with this fundamental speech. I just want to remind in the context of the Zubair, on the 12th of this month, the Supreme Court has given an order and very categorically said we also expect the courts to come down heavily on the officers.
All right, Zubair is out. You can see him over there on the screen right now. He is out of jail. He is a free man, at least for the moment. The investigations against him by a SIT in Uttar Pradesh will have been quashed. The SIT has been removed. The investigation will now take place in Delhi. He is free at liberty, and he's given that V, that sign over there. Freedom, he says. He is at liberty to challenge the cases against him. It is set principle of law that the power of arrest must be pursued sparingly.
सच की जीत हुई, क्या कहना चाहेंगे? एक वर्ड, एक विन, वन वर्ड। हाँ, तो विक्ट्री साइन दिखाते हुए मोहम्मद जुबैर निकले हैं। तो आपने देखा मोहम्मद जुबैर निकल गए हैं, उनकी रिहाई हो गई है। लगभग 23 दिन वो जेल में रहे हैं और अब वो यहाँ से निकल करके अपने घर जाएंगे और कोर्ट ने उनको इजाज़त भी दी है कि वो ट्वीट भी कर सकते हैं, लिख भी सकते हैं, पत्रकार हैं। तो 23 दिन बाद जेल से बाहर निकले हैं। सुप्रीम कोर्ट ने अंतरिम जमानत दी यूपी वाले सारे मामलों में। अब अपने वकीलों से चर्चा करेंगे। उन्होंने बयान नहीं दिया, पर विक्ट्री साइन, जीत का सिग्नल जरूर दिया है। तो फिलहाल मोहम्मद जुबैर 23 दिन बाद निकले हैं। उनके वकील काफ़ी खुश हैं। सुप्रीम कोर्ट ने राहत दी है और हम जानते हैं किस तरीके से पहले सीतापुर में उनको बेल मिली, तो लखीमपुर वाले केस में गिरफ्तार कर लिया गया। लखीमपुर के बाद हाथरस में, दिल्ली वाले में बेल मिली, तो उनकी एक FIR चंदौली में पाई गई। तो एक जस्टिस चंद्रचूड़ ने कई टिप्पणियां भी की हैं। उन्होंने कहा दुष्चक्र लगता है। तो एक बड़ी राहत सुप्रीम कोर्ट से मिली है। मोहम्मद जुबैर अब बाहर गए हैं, वो बेंगलोर के रहने वाले हैं, वो देश में कहीं भी जा सकते हैं और ट्वीट करने पर उनकी कोई पाबंदी नहीं है। सहयोगी सुधीश कुमार के साथ सौरभ शुक्ला, NDTV इंडिया।
All right, breaking news now coming in. Mohammed Zubair, the alt news fact checker, is out of jail. He's walked out of Tihar jail at 9:06 this evening. This on a day when a lot of people would suggest that there's been a victory for personal liberty and the freedom of expression by the Supreme Court after this man, Mohammed Zubair, was harassed day after day, week after week for essentially doing his job, fact-checking as a journalist on alt news, which has won international recognition. Several lawyers have said that the method of arrest which was used was wrong. Several have said that the manner in which he was hounded was wrong. It curtailed his basic right to liberty, to the freedom of speech, and reflected very poorly on the state of democracy in our country. He's not said anything to us. It's only NDTV's Saurabh Shukla who we could actually see on that frame with our NDTV mic over there. I make that point because it's not as if there appear to be dozens of journalists over there trying to get a soundbite of this man in a democracy where we thrive on the freedom of speech. It's just that one NDTV mic to try and get a reaction, as if that man is a villain. He's not. He's a journalist, he's doing his job, and he has the right to express himself and say what he wants. And if he is wrong, as the Supreme Court made clear, he is accountable in a court of law, but not through harassment. It is a set principle of law that the power of arrest must be pursued sparingly. In the present case, there is no justification to keep him in continued detention and subject him to an endless round of proceedings in various courts. That's what the courts said today. Those opposed to his freedom in court today said, stop him from tweeting, to which the Supreme Court said, it is like telling a lawyer to not argue any further. How can you tell a journalist that he cannot write? If he does something that violates the law, then he is answerable to the law. But how can we take anticipatory action against a citizen when he is raising his voice? Every citizen is answerable for what he does in public or private. We will not place any such order. Ashutosh, a quick reaction. Zubair out of prison. Your first thoughts. Keep it brief. I'll get more reactions.
It's a sad commentary on Indian democracy, and it's a sad commentary on Indian judiciary also. And I'm saying this with the full responsibility. See, you remember a week back on 12th of this month, the Supreme Court has said the bail should be rule and the jail should be exception.
Yes.
This is not the first time Supreme Court has said. Supreme Court has laid down guidelines that why a person should go to a jail if the punishment is less than 7 years in Arnes Kumar versus the state of Bihar. But despite that, no state government is willing to implement that. And the Supreme Court, on his last judgment, has very categorically said that the central government should come out with a law in this context. Will the central government come out with a law? And why I'm asking questions to the judiciary also, because in this judgment, the Supreme Court has said, we all expect the courts to come down heavily on the officers effecting arrest without the due compliance of Section 41 and Section 41A. We express our hope that the investigating agencies would keep in mind the law laid down in Arnes Kumar case, the discretion to be exercised on the touchstone of presumption of innocence and the safeguard provided under Section 41. Now, the issue is, Supreme Court is saying this. If the Supreme Court say that in Zubair's case, it's a vicious circle, Supreme Court should come down heavily on the officers who had put this man in jail for 23 days. Why Supreme Court has not done that?
For a moment as well, Mr. Pathania, as a spokesperson of the BJP, how do you react to this? Many of the charges against Zubair were filed in Uttar Pradesh. Some suggested that he'd heard religious sentiments, but the court said that you can't just keep arresting him. It makes no sense. The power of arrests must be pursued sparingly. The SIT, which was constituted in Uttar Pradesh, that's been disbanded. Your reaction?
Vishnu, the Honorable Supreme Court has not given a value judgment comment on the merits and demerits of the criminal charges which are pending against Mr. Zubair.
Yes.
My very, very respectful submission to the learned viewers and the learned panelists who have spared their valuable time to come on this esteemed news channel, sir. This is simply an FIR, first information report, and filing or non-filing of an FIR, this is the subjective satisfaction of an investigating officer. Let's not wage an all-out battle involving Modi and Bharatiya Janata Party and the Union Home Ministry.
I have not raised that, at least. Sir, it's not happened on this program.
Sir, you have said.
I have said, and I will repeat that question, in the state of Uttar Pradesh, where there are many FIRs against him, how do you react to the fact that the Supreme Court of India has said that the SIT which was formed is disbanded? That's my question to you.
Sir, the right to freedom of speech and expression is a fundamental right in India.
Yes.
But this right to freedom of speech and expression is always subject to certain reasonable restrictions. And certain reasonable restrictions which have been affirmed by the highest court of the law.
So would that freedom of restrictions mean this man should stop?
It's not an sir, it's not an absolute and an untrammeled right. In a sensitive, we could say, country like India, which has multicultural, which has multi-religions, which has multi-linguistic minorities, nobody could be given a free run.
Right, and therefore, you are accountable to a court of law. But there is more than a reasonable amount of common sense which people need to apply. If you're going to take a 25-year-old Hindi film and say, and he makes a tweet on that, you use that as the basis to harass this man, case after case is filed on, which basically cuts down on his freedom, then
sir, there's an already court judgment. Whatsoever may be the source, whosoever puts it on social media, he's liable.
No, but puts what is the question, sir? If I take, for example, sir, just one point, I'll come back to you. If I'll come, I promise you, I'll come back to you. If I take offense at what you're saying, and I just go to the court, does it make sense? It doesn't. If you take offense to what I'm saying, right, and I go to the court, what is this? We can go on forever. Why can't we respect in this country your right to say respectfully what you want, my right to say respectfully what I want, without suggesting that we are trying to hurt somebody's religious sentiment?
That's it, sir. That's the only reminder, sir. By respect, everybody has the right to say anything, but subject to the reasonable restrictions which have been framed by the constitutional framework. I'll just quote one sentence, sir. There is a landmark judgment of Justice V.R. Krishna Iyer. You first stir up a hornet's nest and then you complain of being stung.
Sorry, he stirred up a hornet's
nest. So Mr. Zubair, he's given to the habit of, sir. He was guilty of.
We are both respectfully aware of the hate.
He was guilty of misreporting Lakhmipur and Kheri case, sir. Right. He is guilty of creating adventures.
Right, and nothing happened in the Lakhimpur Kheri case. The Lakhimpur Kheri case, it was investigated, am I not right, by the Delhi police? What finally happened over there? Did it not go to a court after that? What was the assertion of the police in that court?
Sir,
nothing came of it.
My respectful submission that an observation of a court, let us suppose, even if a court may, though the court should not make, while giving a judgment on a bail application, that doesn't constitute a value judgment comment on the merits and demerits of the case. This is the law which has been settled.
No, it may not. You're absolutely right. The FIRs, by the way, he still retains the right to move a court, right, to try and quash the FIRs against him. But sir, it is a set principle of law that the power of arrest must be pursued sparingly. In the present case, no justification to keep him in continued detention and subject him to an endless round of proceedings in various courts. The process is the punishment. That's what's being done over here, Mr. Pathania.
Sir, my respectful submission, I am not at all acting as a spokesman for
I know, I'm not saying, but go ahead, yes.
The concerned investigating officer or the concerned SHO who has arrested him, he might have arrested him on the basis of some subjective grounds. And
all
if
of them,
are not subjective,
all of them, all what, 6 or 7 cases, all had subjective grounds.
But let's not make it as a pan-India issue, sir.
Okay. All right, Swati Singh Malik. Swati Malik.
Habit of stirring up a hornet's nest. So we should not make it.
Ranbirji, half a sec. Let me just bring in Swati Malik as well. Is this a victory of liberty and of the right of expression and of putting an end to case after case, Swati Malik? Or is this, in fact, just a step? It doesn't mean that he may not end up back in jail.
Vishnu, well, legally speaking, this is just the first step, and we are very glad that he's out of that jail after 23 days. But what I would like to say here on behalf of Congress Party is that, the central government, the leadership should actually take a hint from what has been coming from the Supreme Court. The observations made by the Supreme Court about how these arrests should not be made or how these frivolous FIRs should not be registered one after the other just to harass one. Now, all these things should be taken a little seriously by the government, and they should stop trying to suppress this voice of dissent. It is my right to dissent. You cannot take it away by threatening me by ED or threatening me with those, multiple FIRs or threatening me with whatever other manner you can choose to harass me. You cannot take away my right to dissent, is what I would like to tell the central government here on behalf of Congress Party. And this is exactly what the Supreme Court has also said today. Of course, and another thing I would like to say is that, how Supreme Court deals with the matter, this does not give any of us a license to troll the Supreme Court, to troll those judges, to, make those personal allegations and attack their families, etc. We have to respect the Supreme Court. We might not agree or disagree with whatever comes from it, whatever judgments come from it. We can criticize those judgments, but we cannot make those personal attacks. We cannot try and create that kind of a pressure. But here, Zubair walking out is a very pleasant sight. As you showed at 9:06, he walked out. It's a very pleasant sight. I hope he does not give up his strength and his power and his conviction to continue with those fact-checking that he's been doing. And even as far as the content of what he wrote, right? All that is, of course, it's sub judice and it's going to be decided after trial, etc. But yes, to the common sense, it was very frivolous for these multiple FIRs, one after the other. He gets bail in one, he's arrested for the second. He joins investigation in Delhi FIR, he's arrested for one in UP. So that one after the other. And if you notice the pattern, what happened against Zubair and what happened against Nupur Sharma on the other hand. She also had multiple FIRs, but no arrest was made. No arrest in any of those FIRs for that matter. So when you see a comparison in a complete, strike contrast rather in the kind of treatment the two of them got for similar multiple FIR cases. Of course, both of them have gotten the relief from the Supreme Court now. But when you see the government and the Home Ministry tackling the two situations, which are quite similar, but and multiple FIRs, clubbing of FIRs in such different manners, that is when you see the bias, and that is when you want the central government to be the central government, not to be, there is a difference between a government and a leading.
Okay, half a second, Swati. Mr. Pathania, would you like to respond to that? Sometimes comparisons are odious, but just in the manner in which the prosecution went after Mohammed Zubair in this manner, he's been in jail for several days now, whereas Nupur Sharma, while relief was given to her partially by the courts, she was not prosecuted in the same manner. She was never behind bars. What about the fact that she offended the religious sensibilities of many around the world, evidently? Isn't that a bias?
Without any offense and without any prejudice, or without acting, we could say acting as a counsel or a spokesperson for Nupur Sharma or Mr. Mohammed Zubair in or against them. So you see, Nupur Sharma has ultimately been protected by the Supreme Court till today only. So what she suffered in the Supreme Court, everybody saw, everybody witnessed, everybody discussed, everybody debated. Let's not draw an analogy. Nupur Sharma was a separate case, and the Bharatiya Janata Party stand in that case was very much clear and categoric. In this case also, particular, my respectful submission means that the law of the land needs to be observed in its true letter as well as spirit. This is what we could say the dividing line remains, sir. Nobody has an untrammeled right.
When you talk about the law of land,
my learned friend says nobody is trying to take away the right to dissent. And if somebody takes, we are with you, madam. We are not at all joined the issue on
then what happened
the right to dissent. Not at all. But if somebody muddles the peaceful atmosphere, somebody hurts the religious sentiments.
What
if somebody creates a show, if somebody creates issues out of thin air, sir. If issues are being created just out of thin air,
exactly, sir, that's the worry. Issues are being created out of thin air.
That's what I'm saying.
Mr. Lekhi, just from a legal standpoint, and I know that you cannot necessarily compare each case, but the fact that the prosecution has not gone after Nupur Sharma in the same way, the fact that she has not been put behind bars, there is not in the same way, does that indicate some sort of a bias? Both cases are linked in a manner. The events are linked, certainly.
Well, perception is very important, and if on assessment of circumstances there's an assumption that law is not operating equally, then that suggestion is necessary to be addressed. I agree that as far as the power of arrest is concerned, initiation of prosecution, it's not only at the center, the states too. Depending upon whichever party is in power, arrest is weaponized for the purposes of political intent, and that's the reason why there's actually undermining of law. You're absolutely correct. As far as similar situations are concerned, they should be equally handled. And if it is wrong for the geese, wrong for the gander too, and there's no question of discriminating one between the other. A wrong is a wrong and has to be addressed as such. But the unfortunate reality is the permeating of politics into law. And it is in this context itself, the sanctity of the legal process in some way affected. And here, that I come back with a comment, because of the permeating of the legal process with these comments. The comments itself, insofar as they become provocative, and I come back to this particular thing, you have the rightful disagreement that aspect is concerned. But I actually feel that we as a country are now leaning too much towards religion and using religious terminology for the purpose of making political comment. And this is something which has necessarily to be avoided, because you can make a political comment without bringing religion into the issue.
I think that's an important point. In a country where religion is so sensitive, it's important for all people, particularly representatives of political parties, I should suggest, to be careful about how they bring up religion.
As also you and me. A secular discourse has to be away from religion.
Look, I'd like to thank you all very much for joining us. Let's just go full frame one more time to these pictures. Mohammed Zubair is a free man. He is out of jail. Didn't say anything to our waiting NDTV cameras, just flashed a victory sign. Hopefully we'll hear from him in the future. The SIT investigating the cases against him in Uttar Pradesh, that's been disbanded by the Supreme Court, which has affirmed his freedom and liberty and his right to tweet as a journalist. That is a victory for our democracy. A couple of cool comments. Adarsh writes in, says, Zubair should be at liberty to seek quashing of the FIRs before the Delhi High Court. He is. Another comment, is he being falsely accused? So a couple of views there. We'll continue this discussion with my colleague Nidhi Razdan in the next few minutes. Stay tuned.